is that the only enforcement capability that Florida offers for HOA laws is civil litigation. Civil litigation requires the private homeowners to pay for lawyers to take on the HOA. You talk about a David and Goliath situation. The Poinciana HOA with 26,000 properties and 50,000 people has an unlimited supply of money that they can spend on legal resources. As I said, we have spent over $80,000 with our own lawyers as far as litigation against these guys, and we're not even at the end of the tunnel right now. We've got litigation that's been in process for over 2 years because every time we turn around, their lawyers are filing more issues that require us to pay our lawyers in order to counteract. It goes on and on and on because they have unlimited resources available to them to pay lawyers, whereas the only resource we have as homeowners is what we, the individual homeowners, can come up with to pay for our lawyers. So what I would ask as far as HOA legislation is concerned is to strengthen the enforcement capability, take it out of the civil litigation arena so that you're putting the burden on the homeowners to come up and do the job for enforcement, but make it a criminal crime. If in fact, and we most recently had it as far as the HOA election is concerned, I mean, DPPR has the state statute right for mandatory binding arbitration. Everybody knew about that. There was an open case. The HOA had appealed that. That appeal was open. Meanwhile, the HOA and the developer go to the 10th District Circuit Court. They never tell the judge in the circuit court that there's outstanding DPPR decision waiting for it. They never invite DPPR to be a part of the case. They never invite the homeowner who filed the complaint to be a part of the case. But yet they together, because they say we don't have a dispute between ourselves, they together got the judge in a 15-minute ruling to issue a 10th Court circuit order that completely negated the order that DPPR had issued as far as how the election was supposed to be held. Now that's going to go on. We filed another complaint with DPPR. We've got another circuit court hearing scheduled for the 20th of November. Surprise, surprise. That was the earliest that Avatar and APV could be available to hear it. All of this is costing money to our homeowners. In the meantime, the HOA continues to go ahead and do that. They're now going to cast another budget with their members that were not elected legally according to DPPR, and they're going to levy another set of assessments against the homeowners. Taxation without representation. We fought a Revolutionary War about that, but in Florida, if you live in an HOA, you have no choice. If the developer controls that HOA and if the developer continues to be allowed to cast votes, which happens in Poinciana, Avatar was allowed to cast 9,000 votes in the last election representing parcel of properties that are underwater. They will never, ever be allowed to build houses there. But because there was a contract that was signed between the HOA that was controlled by Avatar and by Avatar, the judge said there's a binding contract there that says they're allowed to have those votes. Well, yeah, when the developer controls the HOA and when the developer has an attorney negotiating with, in essence, himself, he can get any contract signed he wants that can benefit him. And that's what's happening in Florida.
All right. Thank you.